Now, Varanasi District Court's decision on the Gyanvapi mosque case is the big headline of the day. It's being touted through the day as a win for one community and a loss for another. It's being held up as a right to pray contest. What it essentially is step one in a long legal battle that has just begun. So let's break it down for you. What exactly has happened today? The Varanasi District Court heard pleas of 5 petitioners who want the right to perform Hindu prayers inside the Gyanvapi mosque complex in Banaras. The case is in this particular court on directions from the Supreme Court. Earlier, this case was being heard in a sessions court, but the Supreme Court felt a more senior judge with more experience needs to hear the case, which is quite complex. This district court was faced with a plea that basically said the 5 petitioners, who are 5 Hindu women, demanding the right to pray in the mosque complex, shouldn't be entertained on various grounds. In response, this district court today allowed the petition of the 5 women to move ahead. As a consequence of this, the court now will go into the merits and demerits, arguments and counter-arguments of the case. So, what did the petitioners say? Let me begin with the plaintiffs. The 5 petitioners essentially want the right to worship at the site through the year. Currently, they offer prayers and are given entry in the complex only once a year on a specific religious occasion. They also argued that there is no mosque at the property, that the deities that they worship were present even on 15th August 1947. So the law that says you can't change the character of a place of religious worship does not apply here. They also go on to say that they're not trying to convert the mosque into a temple, but simply want to offer prayers every day like they did before 1993. The other side, that's the defendants, the Masjid Committee who runs the Gyanvapi Mosque complex, in turn has cited the Places of Worship Act, 1991. That does not allow changing the character of a religious place. Now, this act is important. It's important to the story. And there is also a plea on this going on in the Supreme Court. We told you about it last week. So this specific act says that you cannot change a mosque into a temple or a temple into a mosque or one religious place into another if they were that way on 15th August 1947. No changes after that. They made an exception for the Ram Janmabhoomi. Now, the defendants in this case, that's the Masjid Committee, also says that this mosque has existed for 600 years, prayers are offered regularly, and the property belongs to the Waqf. Waqf is a charitable property of the Islamic religion recognized by law. Now, why does all of this matter? Why such a big hue and cry about, like I said, step one of a long legal battle? That's because there are going to be quite a few implications of this court order. This means essentially that the court will hear both sides of the Gyanvapi case. The court decision today could also lay precedent to other similar claims, which is why today so many people are talking about Mathura and the claims over there. There could be other kind of disputes which will come up. And the question is, will a legal precedent be set where symbols of different religions coexist? This is not so unusual in India, where you will have the symbols of one religion in a place of worship of another. It also reflects our very, very long history. So, will the judgment over here have consequence on all of those future disputes? It also will have impact on legal challenges to the Place of Worship Act 1991, which the Supreme Court is hearing right now. Now, the question is, what happens next? We told you this is step one. So, this case is actually being heard in 3 different levels of courts. On September 22nd, the same court which passed the order today, the Varanasi District Court, will be hearing the Gyanvapi Shringar Gauri dispute. On September 28th, the Allahabad High Court will be hearing a plea by the Masjid Committee over an ASI survey. Because remember, when the Sessions Court was hearing this case, the Sessions Court allowed the Archaeological Survey of India to go into this complex and videograph the place. The Masjid Committee has filed a case against this in the Allahabad High Court, which they will then hear. Meanwhile, on October 20th, the Supreme Court will be hearing the Masjid Committee's objections over the civil suit, where they opposed the maintainability of the civil suit. The same thing that they opposed here in the district case, in the district court, the Supreme Court will hear it as well. So essentially, you have a number of steps now in this legal battle. Why is this legal battle important, and why is it important to understand the implications of it? To speak on this, I'm joined today by Prateek Som, advocate of the Supreme Court and national spokesperson of the JJP. But he's speaking today as a lawyer. Touseef Ahmed, senior lawyer, also with us on the show. So welcome to both of you. Mr. Som, let me come to you first. Does this truly have implications for the Places of Worship Act 1991? Because in this particular case, the plaintiffs say that all of these structures, all of the deities existed before 15th August 1991. Will this be looked as a workaround around the 91 Act?
See, first of all, just to give you a brief background, that each and every law made by Parliament and which culminates into an act is open to a judicial review. Now, let me take you to the view of Supreme Court on 30th July 2022, when this matter was taken up. The Honorable Supreme Court said that when there is a dispute between two segments of the same community as regards place of worship. Now, what they say, the same might require leading of evidence, and hence the correct forum for remedy is the trial court. That is what been told by Supreme Court on 30th July 2022. Now, as far as the Places of Worship Act is concerned, and the bar subsequently, that whether that can be changing of mosque to temple, or maybe allowing other religious people to worship at that place, whether this is barred by lower courts to consider or not. Status of all religious structure as it stood on 15th August 1947.
Let me make this simple. One sec, Prateek, let me make this simple, because I feel what happens very often is we lose our viewers in legalese. So let me ask you again, and I'll request you to make it simple. Why is this being touted as a big victory for one side? Like I said, this is step one, isn't it?
Yes. I'll tell you why it is a big victory. Because now the matter will be heard, and there will be reliance on the court-appointed commissioner report, which says that there was existence of shibling in the complex. And we must not forget that the report of Archaeological Survey of India in the Babri Masjid case, which stated that there was existence of temple before masjid was constructed, was one of the main factors which was relied upon by Honorable Supreme Court while deciding the Babri Masjid case. So the whole point of contention is that now that that court-appointed commissioner report will be considered by the court, whether the trial court or maybe under the challenge of High Court or maybe with the Supreme Court. So that forms the basis of the pleadings now. So in today, when this application order 7 to 11 was decided against the Muslim sect, it will consequently lead to consideration of all the pleadings, which will include the court-appointed commissioner. This is one point. Now, other point which I wanted to make is
simple.
This particular case, the Hindu party's claim is only limited to the right of worship. They are not asking
Prateek, there is a contradiction there, because the petition also says first that there is no mosque, and then it says we're not converting a mosque into a temple. So if you're not converting it, why are you claiming that there is no mosque in the first place? I'll come to you on that. I just want to get point by point, because this is, as the Supreme Court rightly said, it's a complex issue, and it has to be looked at in the legal perspective. Touseef, today, this entire story, this development is being painted as a threat to the minority community, to the Muslim community, saying that now after Ram Janmabhoomi, they're going to convert this mosque into a temple, and then there are going to be many, many more. There is no legal basis to that, is there?
There is absolutely a legal basis to that. And there are two aspects to this whole verdict which has come out today. In the aftermath of the verdict, what we have seen is that one side is celebrating in rejoice, and then they are saying that now the next step would be this is just the first step, it's a big victory, and then the next step would be, as we all know, as it is their claim, that this mosque was a temple and it has to be removed, the mosque have to be removed and a temple has to be built. You see, there are two aspects to it. Please be patient with me. One is the history, a concocted and half one-sided and hatred-filled history that is being repeated today in the social media and through TV channel debates. What is that history? A hate-filled history. And I'll present the second, the other side of that history. The fact that I want to reiterate today is with regard to Aurangzeb. You know, Aurangzeb demolished temple is what is being told. But they are not telling the full truth that Aurangzeb also gave grants to temple. What were those temple? The temple of Mahakal temple in Ujjain.
Can I just come in there and stop you for a second? Touseef, can I just come in there and stop you for a second and then you continue?
Please do not interrupt me.
Please listen to me.
I asked for 2 minutes
You will get uninterrupted time. Let me just frame the boundaries of this debate. Because the only reason I'm interrupting is because you talked about what is on social media and some people are celebrating. Frankly, I don't care what's on social media. What I'm doing today as a discussion is not about what people are saying on social media. No, I don't. We want to inform people in this debate. That's why, if you've seen, I've invited two lawyers.
You may choose to.
There are no people claiming. There are no people.
When the mosque is demolished, it may not affect you. It will affect the local people.
Touseef, listen to me. Touseef, listen to me. And allow me to frame the contours of this conversation. I have invited two lawyers today to speak about this. You would have noticed I have not invited people claiming to represent any religion. This is a matter of law. We want to see what the legal implications of this, and yes, it does impact society as a whole. It will impact, harmony maybe in society. But today, I want to understand from you whether there is a legal cause of concern for the Muslim community as is being talked about. Is there any legality to it? Because the way it looks like in black and white is step one. They will now begin to hear these claims. We don't know what the outcome will be.
Yes, before coming to the legal aspect, I'll need 20 seconds to complete what I was saying. In 1687, Aurangzeb granted land in Varanasi near the Ghat. He gave land to Ram Jivan Gosain to build residential dwellings of Brahmin and holy fakir. He gave grants to Mahakal temple in Ujjain and Krishna Mandir in Vrindavan. And Aurangzeb demolished a mosque in Golconda because local Nawab had hoarded wealth in mosque and he refused to pay tax. So this demolition drive by Aurangzeb was for political reasons. That's the history I wanted to say. Now let us come to the legal part. You see, the judgment of Babri Masjid was delivered not very long ago, into 2019. In that judgment, the Supreme Court very clearly highlighted that the Places of Worship Act explicitly ensures that the argument of mosque being a temple before would not be treated as precedent for subsequent claims of this sort. Now, when the judgment was passed, the political class, the society, the media, and everyone hoped that this would be an end of Mandir Masjid debate. The people of India suffered because of the Mandir Masjid Jhagda in the past so many decades. And we all hoped that this would be end. Then the Places of Worship Act was passed with the same intention, that no mandir would be converted, no mosque would be converted, places of religious nature would not be converted, religious nature place would not be converted, and this was reiterated in the judgment passed by the Supreme Court. Now, when the Supreme Court puts a bar, can the very vital legal question today is, can the court, by a judicial process, create facts on the ground? Why should there be facts created to determine whether a mosque was a mandir before? Does that not mean that once that is created, Then when the matter reaches, to the higher court, they would say, oh, we cannot do, because we are now going on the path of Babri Masjid. What the court,
Okay.
what did the court say? The court held that the act of demolition was illegal, yet decided in the favor of the mandir, because there was nothing they could do. The demolition took place, an illegal act. Same way, we are heading in the same era. We are traveling back in time.
Prateek, one minute. Your response to this concern. Touseef, you've said it. One second. Let me just get a response. Because Asaduddin Owaisi said the same thing today, and we'll play out some of the responses which came in through the day. Said that this opens the Mandir Masjid debate and dispute once again. It will not stop here. This will go down the Babri route. What do you say to that? Do you think that today's judgment is laying the precedent for the same route?
See, up to the point of Supreme Court carving out an exception in the Babri Masjid case to the Places of Worship Act, I agree with my learned colleague on the panel. But let me just remind him that being a lawyer, he should also know that all the acts are subject to judicial review. If this is the case, let me give you a classic example that Citizenship Act came much before these acts came into the power. And now when there is a Citizenship Amendment Act which has come, that has been challenged in the Supreme Court. Now, what does this mean? This means that subsequently, if any of the act is paid, it is open for judicial review. And I started my discussion.
Prateek, we are diverting. No, we are diverting because now you're talking about the Places of Worship Act 1991, which is being challenged in Supreme Court. I'm speaking specifically about the Gyanvapi case and whether it opens the route to other similar plaints. In fact, the Gyanvapi case will not be looked at as an example of Places of Worship Act because the court today says it does not apply in this case, because it's accepted prima facie the plaintiff's claim that those structures, the Hindu deities and those structures existed as on 15th August 1947, because they worship there once a year. They say they went every day before 1993. So this is not a Places of Worship Act debate as of today. Would you not agree?
See, Tamanna, I have read this order today. Now let me tell you that
so have I,
the
sir.
judge has categorically said in today's order that Places of Worship Act will not be a bar. Why? He has also applied his judicial mind, because the relief which has been sought by these petitioners is only to the extent of doing worship at that place. And Place of Worship Act 1991 comes into play when there is a question of moving the religious place from one place to another, or converting it into one from a mosque to a temple, or a temple to a mosque, or to some other kind of thing. So this is the point in contention. And let me tell you that already there is a ritual in which the Hindu sect is allowed to worship once in a year. Now the only thing which is sought is that they'll be allowed to worship their God more than once in a year. So if Place of Worship Act has to come as a bar, then why allowing them even once in a year? So this is not point in contention. Place of Worship Act is not at all there. Supreme Court has already applied.
You're echoing what I just said, Prateek. But I'm asking you something else. My question to you legally is, does this not pave the way for similar complaints or similar claims, especially in religious places where symbols of more than one religion exist, which is not unusual in India?
No.
It's not unusual in India.
Tamanna, this act has come into force in 1991. How many years?
I'm not talking about Places of Worship Act. Prateek, can I please repeat my question again? I'm not talking about Places of Worship Act. I'm talking about what the district court has said today. And the reason the district court has gone into this today is because the fact is that religious symbols of two religions have existed in the Gyanvapi mosque complex for years, which is why there was worship allowed once a year on a specific occasion in the complex. And now these petitioners are saying we want to do it every day. This is not the only place like that where the symbols of two religions will coexist. Does today's order open the path for similar claims that I want to go in and worship because the symbols of my religion also exist?
I will reply on that point. see, there can be a reasonable apprehension regarding that. But what we have to understand is that courts decide on the codified laws. And as far as the religious matters are concerned, even my learned panelists will also agree with me that in India, there are less codified laws as far as religious matters are concerned. So it is more appropriate that a mediation or conciliation talk should take place before the court applies judicial mind. There is a reasonable apprehension, which I also agree, that it may open a Pandora box, but ultimately courts will have to rely upon the codified laws which are scarce at this point of time in India.
Okay, Touseef, your response to that question, because that's where it actually sits, isn't it? Where there is clarity that this is a mosque and this is a temple, perhaps the same disputes will not arise, and the Places of Worship Act 1991 and its challenge is a different discussion for a different day. But where dual symbols exist, does this then set a precedent for similar claims? Is that the concern?
No, you see, before 2-3 months ago, I mean, when this claim just erupted, you know, that the Wazu Khana, the fountain in the Wazu Khana, is actually a Shivling, and therefore this is a temple. So please look at the Babri Masjid on one side and then Gyanvapi case on the other side. Babri Masjid, people used to offer prayer. Gyanvapi Mosque, people are offering prayers. Babri Masjid, an idol was placed and then people demanded to worship that idol. Gyanvapi, an allegation is made that there is Shivling and then we will want to worship it. So we are going in the same path. And where in the Babri Masjid judgment by Supreme Court, it is specifically said that the argument that a mosque was a temple before would not be entertained. So if this argument Supreme Court when 3 years ago had said that such an argument would not be entertained, then why are the courts entertaining it now? Does this not amount to opening of the Pandora box? Can anyone today on affidavit say that no, my claim is not that this was a temple, Gyanvapi Mosque was a temple before? Has the petitioner said this on an affidavit before the court that no, I do not claim that the Gyanvapi Mosque was a temple before, or that there is the Shivling is found there? They are openly saying it. It is everywhere. It is a writing on the wall. The claim is that this mosque was a temple before. Then where are we heading? We cannot turn blind to the writing on the wall. It is a simple and clear, open and shut case that this is going towards the Babri situation, which we must at all cost avoid.
Prateek, your response to that last point, this is going the Babri way and it opens up a Pandora's box.
Yeah, I think now we are disrespecting what Supreme Court said in this particular matter on 30th July 2022, that these type of matters should be led by evidence, and that is only possible for trial court to rely upon. If Supreme Court has applied its judicial mind and has
evidence means creating facts.
Appropriate orders. No, it is not a fact. It is a belief. There is a reasonable difference between a belief and a fact. When some community believe up to a certain point, then who will decide? It is only court which can decide. I mean, whether it is to be decided or not, that has been decided by the Supreme Court on 30th July 2022. Please read that order, otherwise I will send it to you.
Okay. Now, 1 minute. I want to ask a broader question over here. Of course, both of you all are lawyers. You'll have given us your legal point of view, and it's going to go through a long, lengthy court process. We've laid out how this is being fought at various levels in various courts. But as also members of civil society, Touseef, are you concerned that more and more pleas like this will create strife in society? Or should we look at this merely as property claims? At the end of the day, they are claims over pieces of land where there is faith attached. How should we be looking at these cases so as to avoid strife in society?
Let me, to this answer, let me quote Paulo Coelho, the famous writer who wrote The Alchemist, because I have seen this and experienced this in my personal life as well. That anything that happens once may not happen twice. But if anything that happens twice is bound to happen again and again. And going by that logic itself, the Places of Worship Act was passed, the judgment was delivered on those lines, believing on those principles that this Babri Masjid, the Mandir Masjid Jhagda, is only one and only place, only Babri Masjid. Let us convert this into a temple, and there would be no further claim. Yet we see, because this slogan कि बाबरी एक झांकी है, मथुरा काशी अभी बाकी है, something like that, this slogan is being chanted everywhere, every day. Can we turn blind eye to that? Do we want to go back in those paths? Shall we travel back in time?
I'm sure. Okay, let me get Prateek to also respond to this question. Prateek, surely nobody wants increased strife in society or a large section of society to feel insecure that their places of worship are going to be targeted one by one. How do we avoid this while looking at all of these disputes?
Tamanna, as an officer of the court, and which my learned panelist is also, I think we should not be influenced by what is happening on social media, what kind of slogans are coming up, which my learned panelist has just, quoted. We should only be concerned about the present laws, the present, situation, and how the courts can, adjudicate on that particular point. If we will be, influenced by the social media, we will be the one among the masses. But courts do not get influenced. There are plethora of judgments where the Supreme Court has said that we are not concerned what is happening on social media. See, it's the voice of 135 crore people. You cannot, put all the arguments.
Not social media. I've quoted the famous writer, author.
All right, there can be different views, but what is to be seen is that there are two acts presently as far as these kind of situations are concerned.
I am quoting the alchemist Paulo Coelho, not social media.
One minute, let him complete. I think he's talking about your subsequent comments. But anyway, yes.
One fact which is not applied in this particular case because the plaintiffs are not Muslim. Point number two, that Places of Worship Act is particularly up to the extent that the places of worship like mosque and temple cannot be interchanged or removed from one place to another. In this particular case, there is no such kind of relief which is sought. The only relief which is sought is allowing of worship at this particular point. Now, I have also quoted that why this today's order has become very important because that the court will hear the case on its own merit and the pleadings will also be taken into record. That will also contain the court-appointed commissioner report which says that shivling has been found at this particular place and that has also been videographed. I am not advocating any particular side, but I am just telling you that this same kind of report was given by Archaeological Survey of India in Babri Masjid's case, where it stated that prior to Masjid, there are clear evidence.
So Prateek, you are saying exactly what Touseef is saying. You're proving his point. He's saying this is going to go to the Babri way, and you are citing what happened in the Babri case. So you're basically echoing his point, isn't it?
Beliefs are much different. You have to understand. Having a right of worship is different from, asking for a particular land. Particular place.
But once you begin worship of a certain religion in a site, can you not then say that this site is then a temple? Then that's the legal question which will come next, isn't it?
That has not been even asked for. We are going beyond that. This is one's imagination. It is one's imagination in whole of the plains that is not even asked. The relief is not sought like in this fashion.
This is an important legal case, but let's just put things into perspective. Do we want to get back to Mandir Masjid politics once again in this country? Does the India of 2022 need to focus its energies on this issue is a question we should all ask ourselves. Thank you so much, Touseef and Prateek, for joining us on the show. I just want to play out some of the key reactions which came in today to the Varanasi District Court's judgment.
आज कोर्ट ने हमारे सारे आर्गुमेंट्स को मान लिया है, मुस्लिम पक्ष की एप्लीकेशन रिजेक्ट कर दी है, प्लेसेस ऑफ वर्शिप एक्ट की उनकी जो प्ली थी उसको खारिज कर दिया है। वक्फ एक्ट की प्ली को खारिज कर दिया है। कोर्ट ने कहा है कि सूट मेंटेनेबल है। अब इस मामले की अगली सुनवाई 22/9 को होगी और एविडेंस लीड की जाएगी।
इंतजामिया कमेटी की तरफ से ये दरखास्त पड़ी थी कि जो मुकदमा दाखिल हुआ है वो चलने योग्य नहीं है। वो दरखास्त जो इंतजामिया कमेटी की खारिज हुई है उसके खिलाफ इंतजामिया जाएगी हाई कोर्ट में। बस 22 सितंबर पड़ी है। अरे अभी तो सब लोगों को जवाबदेही वगैरह लगाना पड़ेगा ना उसके बाद। हाँ तब अब तो मुकदमा चला ना, अब चलेगा मुकदमा, देखा जाएगा।
1991 का जो प्लेसेस ऑफ रिलीजियस वर्शिप एक्ट है वो तो उसका मकसद ही फेल हो जाता है, क्योंकि 91 का एक्ट इसलिए बनाया गया था ताकि इस तरह के कॉन्फ्लिक्ट जो है वो हमेशा के लिए ख़त्म हो जाए। मगर आज के ऑर्डर के बाद ऐसा लगता है कि फिर अब ये लिटिगेशन शुरू हो जाएगा इन तमाम इश्यूज़ के ऊपर और हम दोबारा 80 और 90 के दहे में वापस जा रहे हैं फिर।
और बाकी न्यायिक प्रक्रिया जैसे चलनी है वैसे चलती रहेगी, लेकिन सभी पक्षों से मैं यह जरूर अपील करूंगा कि इस फैसले का मैं भी स्वागत करता हूं, सब लोग स्वागत करें और